Hi, good morning, seniors, and thank you for joining today's tutorial session on the law of interpretation. Like I mentioned yesterday, this is my very modest contribution to your academic journey as you prepare for that important October call. I want to assure you that this series will not only end with the law of interpretation, but we will extend it to other courses that are of equal importance to you. Please, with your permission, let's allow for some 5 minutes whilst other colleagues join. Once again, thank you and then welcome. Yeah, hi. Hello, Senior Telfer. I don't know if you can hear me.
Boss, I can hear you. If I'm audible, you may please begin the recording.
Okay, so I have started that already. So when it's 9:10, I think we can start. That's barely a minute away. So we
That's
don't
fine.
keep those on the call waiting for too long.
That's okay. Thank you.
All right, thank you too.
Right. Good morning, everyone, and thank you for joining us for part two of the Hit the Ground Running series as part of your preparations in terms of the final exam, your part two exam, and we have been focusing on law of interpretation. Yesterday, we spent some time to look at the approaches to interpretation, but we began first by trying to provide a broad overview as to what is the scope of the law of interpretation and what the end goal was when it came to interpretation. In effect, we tried to draw out, in a certain sense, an analogy that suggested that interpretation arises when you are giving a particular set of facts and you have an understanding of the approaches, the rules, and the aids to interpretation, then it provides you an opportunity to provide the legal meaning of a text or a phrase that you, as an adjudicator, has been provided with in respect of a set of facts before you. So ultimately, your goal should always be to answer the question of what is the true legal meaning of a text or a phrase, and how best does the interpretation approach, rule, or aid you have adopted, how best does it effectuate the true intention of the maker of the document. We noted that we have gotten to a point where it is almost agreed in terms of consensus that when it comes to interpretation, the goal of the person doing the interpretation is to find the intent of the maker of the document and give effect to same. And so all the approaches, all the aids, all the canons, they go to one point, which is to try and provide the intent of the lawmaker. And we spent some time to look at some of the approaches. We looked at literalism or strict constructionism, where we said this is approach where the ordinary or literal meaning of the words, even if it may result in an absurdity, are deferred to. And we noted that once the text is clear and unambiguous, the intention of the maker of that statement is in the text, and there should not be any recourse to a secondary meaning. But we also highlighted that oftentimes, when the literal meaning will render an absurdity, lead to an inconvenience or an injustice, there are instances where we may rightly refer to a secondary meaning. We also noted that uh, we should provide the strict technical meaning for words once they've acquired a technical meaning. So we noted that once the word acquires a technical meaning or is a term of art, it must be construed in accordance with that meaning. Sorry. And we also clarified that the Supreme Court of Ghana has emphatically rejected the literal approach to interpretation as an unreasonable and unfair means which may render absurd consequences. So in Ghana, we don't appreciate the literal meaning. We discussed textualism as well, where we noted that the interpretation was based on the ordinary meaning of the text, but is considered within the context that the words are used. We also looked at intentionalism, which, if you like, provided a three-step process, which we'll come to talk about much later in respect of the approach to interpreting a non-statutory document. So that is where we ended yesterday. And we noted that today we're going to continue with our discussions on purposivism and the modern purposive approach to interpretation. So that is what we are going to spend the next hour or two looking at. Are there any questions arising out of yesterday's discussion? Are there any contributions, something we are missing you want to add before we proceed, please? I presume not. Okay, Vitus, please go ahead. Vitus Domo, your hand is up. Please go ahead.
Hello, can you hear me now?
Yes, please, I can.
Yes, good morning.
Good morning.
Please, I wanted the authority that condemned literalism in Ghana, if you have it offered, or if you can maybe get it later on.
Transport France against the Electoral Commission and Attorney General. And you
Okay.
also see the case of Dansu Champon against the Attorney General in another.
Okay. Thank you very much.
That's fine. Great. So let's proceed with our discussions on the purposive approach to interpretation. As I noted yesterday, there has been an agreement, or where the academic community, the judicial community, we're all in agreement that when it comes to interpretation, we are looking at identifying the intent. And purposivists appear to have hacked it, if you like, in terms of the best way to ascertain the intent in the interpretative process. And so that is what we are going to be looking at: purposivism, and then we'll come to the modern purposive approach to interpretation, which has two offshoots. That is Aaron Barak's formulation of purposivism, or MOPA, and then we'll also look at Bennion's approach to MOPA and the way in which the two differ. So let me share my slides. Thank you. Just a second, please. Please, can you see my screen? Can anyone?
Yes.
Okay, thank you. Great. So purposivism is a concept that was introduced in the case of Pepper and Hart, where the court began to analyze the need to depart from a strict constructionist approach to interpretation. And the purposivists assert that in order to better effectuate the intentions of the legislature in making the law, it will be improper to stick to the letter of the statute. And so, in order to allow you understand what the lawmaker intended, it is wrong for you to say, I'm sticking to the four walls of the statute to give effect to same. Remember that we are coming from a place where the idea was that the intention of the lawmaker was fully expressed in the words that he himself used. And so, if there was a drafting error, or if there was something that is not intrinsic in the text, that cannot be considered as material to understanding the true meaning of the text. However, as time went along, due to the constraints and the absurdity that was apparent in providing an interpretation in that manner, the court developed the purposive school or purposivism to ensure that you are able to better ascertain the intent of the legislature by looking to the purpose for which the text was created. And it came to light that a strict constructionist view did not provide a better means of effectuating the true intent. And so, if you wanted to give effect to the intent of the lawmaker, which is the object of interpretation, by the way, you now have to adopt an approach which considers what the legislation was intended to do, what the purpose of the legislation was. And so the courts began to have recourse to extraneous material, i.e., material that was not intrinsic to the legislation itself. So, to ascertain the purpose, you do not only need to look at the text of the enactment itself, but the context within which the words were used, together with the subject matter of the enactment, the scope, the purpose, and its background. So things such as the long title, the memorandum for the in case of bills, the mischief that was intended to be cured, and historical antecedents have all come to be appreciated as part of the body of work that must be looked to ascertain the true intent of the legislature. Again, it's a trajectory we are going on. Remember where we are coming from. We are coming from a viewpoint that says that if you want to find the true intent of the legislature, look to the strict words or look at the words as used in the statute strictly, right? However, we have identified that that could be potentially problematic, and that doesn't, if you like, encapsulate fully what exactly the lawmaker intended. So the purposivists say, well, we need to look at other things, such as not just the literal or grammatical meaning of the words, but the context in which they were used. So if you recall, yesterday we started from literalism, went to textualism, added intentionalism. Now we are purposivism. If you look at it critically, purposivism is a combination of all three schools that we have gone through so far. So the literalists say apply the grammatical meaning. Textualists say, well, look to the ordinary meaning and the context in which the words were used, and read the text as a whole to determine what an objectively reasonable person would have come to in terms of the conclusion. And then intentionalists say, well, apply the mischief rule, apply the golden rule, and then look to provide the whole understanding of the text. A combination of these three schools of thought leads us to the purposivist view, which says that, well, it's important to look at the ordinary meaning of the words, but if they were used in a particular context, pay attention to the context. And the context will also include the subject matter of the enactment, the scope that it was intended to cover, legislative antecedents, the history or historical antecedents that led to the passage of the bill or the act, and then other extraneous material that may be helpful in understanding or determining the true meaning of the words as used in the text. And so the purposive approach now opened the floodgates for courts to be able to use materials that are outside or extrinsic to the act to be able to determine the true meaning of the act. And in Ghana, we have officially adopted the purposive approach as the proper means of interpreting statutory documents. So, can somebody please read Section 10 of the Interpretation Act? Section 10, Interpretation Act. Anybody, please.
Section 10, 1. Where a court is concerned with ascertaining the meaning of an enactment The court will consider A, the indication provided by an enactment as printed, published or distributed by the government printer. Should I go on?
Please go on.
B, a report of a commission, committee, or any other body appointed by the government or authorized by Parliament, which has been presented to the government or laid before Parliament, as well as government white paper. C, any relevant treaty, agreement, convention, or any other international instrument which has been ratified by Parliament or is referred to in the enactment of which copies have been presented to Parliament, or where the government is a signatory to the treaty or the other international agreement, and the travel
Go
preparator
preparatoire.
or preparatory work relating to the treaty or the agreement, and an agreement which is declared by the enactment to be a relevant document for the purpose of that enactment.
Hmm? Please
Should I
continue.
continue?
Yes.
Okay. A court may, where it considers the language of an enactment to be ambiguous or obscure, take cognizance of A, the legislative antecedents of the enactment,
Hmm?
B, the explanatory memorandum as required by Article 106 of the Constitution, and the arrangement of sections which accompanied the bill.
Mhm.
C, pre-parliamentary materials relating to the enactment. D, a textbook or any other work of reference, a report or a memorandum published by authority in reference to the enactment, and the papers laid before Parliament in reference to the enactment. E, the parliamentary debates prior to the passing of the bill in Parliament.
Hmm?
Then
Three,
three,
please. Three, yes.
I should read the three.
Yes, so you stop at 3 for me.
Okay. So, subject to Article 115 of the Constitution, a court shall have recourse to parliamentary debates under subsection 2, where the legislative intention behind the ambiguous or obscure words is clearly disclosed in the parliamentary debate.
So, in effect, what we have just read, and if the Interpretation Act is for you, and you have a hard copy version of the Act, you may annotate under Section 10, purposive approach, so that when you take the Act again, you are fortified in your thinking as to what forms the basis or the foundation of the purposive approach to interpretation in Ghana. The Interpretation Act, by its application, applies in interpreting documents, interpreting statutes and the Constitution, where that interpretation is not inconsistent with the Constitution itself. So the Interpretation Act, if you like, is our guide in respect of understanding the means to go through the interpretative process. It outlines that once a court is considered with ascertaining the true meaning of an enactment, the court may consider indications provided by the enactment as printed, published, and distributed by the government printer. So the original text of the enactment, which you see as the act, is the first thing that the court may look to in order to ascertain the meaning of the enactment. The next thing is a report of a commission, committee, or any other body appointed by government or authorized by Parliament, which has been presented to the government or laid before the Parliament, as well as the government white paper. And then it goes on to say a relevant treaty, agreement, or convention which has been ratified by Parliament, and an agreement which is declared by the enactment to be a relevant document. All of these go to show you that there's recourse to extrinsic or extraneous material that helps understand the meaning of the enactment, because the law admits that there's no enactment that is, if you like, legislated on in a vacuum. Just like it was established in the Hayden case, in terms of the mischief rule, there's always a reason why Parliament does something by way of lawmaking. before Parliament decided to take the step to legislate a particular area, Parliament must have noted a particular thing. So there may have been, social considerations. So, for instance, Parliament is currently legislating on the proper human rights, whatever that bill is called. But the anti-LGBTQ bill, Parliament is currently legislating on it, and so that legislation has been born, according to the proponents of the bill, anyway, has been born out of a certain fear that homosexual values are creeping into our democratic society, and that it is beginning to spread into spaces such as schools, and has the potential of corrupting children and stripping away our Ghanaian family values. So ultimately, if one day there's a contest as to the meaning of the words in that enactment, if it passes, the judge is required or is even encouraged by the Interpretation Act to look to certain materials that may not be found in the act, but that were topical in preparing the act. And that is the idea behind purposivism. So if you look at 10.2, for instance, it says that in considering the language of the enactment to be obscure or ambiguous, you need to take cognizance of the legislative antecedent, which means that if the act had a mother act, or if you like, if the act was spun out of a previous act, then you can look at that previous act to help you determine the true meaning of the words in this new act. So, for instance, Act 992 came about after Act 179 was repealed. And so we can look to Act 179, which is a legislative antecedent to Act 992, to clarify certain things for us. Because oftentimes, the legislative antecedents provide a framework for what is now, if you like, the current position of the law. Because some of the majority of the provisions in 179, subject to, of course, a lot of modifications, were retained in 992. And so if there's some misunderstanding on the meaning of some of the provisions in 992, and we can look to 179, and the Supreme Court has already interpreted those provisions in 179, then we should be fine. Is this clear? Am I making sense? Is anybody confused?
You are making sense. Carry on, sir.
Great. So that is the first thing that the Act asks us to look at. Then we also look at the explanatory memorandum as required by Article 106 of the Constitution. Remember that by virtue of Article 106, unless the bill is one that has financial implications in Article 108, there's a requirement for a memorandum to be provided for the bill. The memorandum explains the object of the bill and outlines what the bill is intended to do. So oftentimes, the courts look to the memorandum of the bill to provide itself with a firm understanding. Because if you've seen a memorandum to a bill before, you would find that it does a clause by clause analysis on the relevance of each clause and provides a general overview of what the bill is intended to achieve. And so it is important that you are able to pay attention to the explanatory memorandum. So, for instance, if you pay attention to the case of Eziame Manan, an attorney general, which case was centered on the legalization of 0.3%, I think, THC, which is the industrial use of cannabis, where the Supreme Court struck down that provision of the Narcotics Control Act to the effect that that provision was enacted in a manner that was inconsistent with the Constitution. The court in that case, if you read the dissenting opinion, did a holistic overview of the object of the bill and came to the conclusion that the object of the bill did not necessarily amount to one that was antithetical to our directive principles of state policy. Of course, the majority in that decision dissented. I disagreed on that score, but I mean, now Parliament has reenacted that, so that goes away. But it goes to the point to show you that oftentimes when there's ambiguity in the or obscure, there's an obscure nature of a word used in enactment, the memorandum is a very good point to start with in understanding what exactly the drafter of the law intended. And that forms a very good platform to build upon your interpretation. There are also pre-parliamentary materials that relate to the enactment, and textbooks, other works of reference, a report of or a memorandum published by authority in reference to the enactment, and the papers laid before Parliament. Oftentimes, when Parliament is considering the legislation, they invite public opinion, and so people may submit their views. I'm sure you noted that when they were having the committee hearings on the Proper Human Values Bill, the various human rights organizations, religious groups, all submitted their position papers to the committee. So all of these may help in understanding the basics or the framework within which the um, interpretation of that particular text of the enactment may go on. However, note in Article Section 10.3 that the section says that subject to Article 115 of the Constitution, a court shall have recourse to parliamentary debates where the legislative intention behind the ambiguous or obscure words is clearly disclosed in the parliamentary debate. So, if you pay attention, and this particular provision is there for a reason. Now, in Pepper and Hart, and under the common law understanding of purposivism, parliamentary debate was not a good source of interpretation. And so pre-parliamentary materials, legislative antecedents, all of those were included as sources of understanding the true meaning of a text or enactment. But parliamentary debates were expressly excluded. But when we decided to include it in our act, we said that we would only have recourse to parliamentary debates once there was a contention as to the meaning of the word. And so if that word was not debated on, or that phrase was not contentious, then parliamentary debates will not be a good enough basis to use to understand the true meaning of the enactment. Who can tell me why this is the case? Why did we decide to say, well, it's only when there was a contest as to the meaning of the word that we allow parliamentary debates to be used to advance the legislative intention? Any ideas? What is the relevance of Section 10.3 of the Interpretation Act? Okay, just think about it. It will come to you. Just think about it. So that is the framework that is provided for in sections 10.1 to 10.3. But now let's read section 10.4. My designated reader, if you may, please read section 10.4.
Section 10.4. Without prejudice to any other provision of this section, a court shall construe or interpret a provision of the Constitution or any other law in a manner A, that promotes the rule of law and the values of good governance, B, that advances human rights and fundamental freedoms, C, that permits the creative development of the provisions of the Constitution and the laws of Ghana, and D, that avoids technicalities and recourse to niceties of form and language which defeat the purpose and spirit of the Constitution and of the laws of Ghana.
So just by reading section 10.4, it leads you to the overwhelming conclusion that, look, when it comes to interpretation in Ghana, we don't care about the strict constructionist approach. We don't care about technicalities, niceties of form. We don't limit ourselves only to the text. We look to other factors. And to other factors such as the rule of law and values of good governance. So if the act is yours, you may underline that. And B, human rights and fundamental freedoms. and C, the creative development of the provisions of the Constitution and the laws of Ghana. The creative development. Yesterday, when I was making the point about and evolving the need for you to interpret the law in a manner that is consistent with the evolving society. And so we cannot consistently be going back to Parliament to pass new laws, ostensibly because society has evolved to another point. The judge must be able to breathe life into the act or the constitution and interpret it in a manner that is consistent with our ethos and social practices as we move along. And so that is why the Interpretation Act enjoins the person doing the interpretation to ensure that he's interpreting it in a manner that permits the creative development of the law and the constitution. And then finally, it says we need to avoid the technicalities and niceties of form and language, which defeats the purpose. So for the first time, you expressly see the term purpose used. The purpose and spirit of the Constitution and the laws of Ghana. And so, just like Sowa JSC said in Tufo and Attorney General, the Constitution has its letter and also has its spirit. Laws have their letter and they have their spirit. When we talk about spirit, we understand that the laws take on a body, if you like, a certain sense that is greater than just the mere words used in the text, because we understand that the laws will not operate in a vacuum or in a silo. The law will operate in a manner that should be acceptable to the people living in the community. And so to be able to allow the law develop to that extent, we need to ensure that we are not focusing on things such as technicalities and niceties of form or language. That is why the doctrine of substance over form always prevails, especially when we are looking at it in the context of our understanding of the use of words in an enactment. So if we're able to evince the true intent by virtue of understanding the purpose, then that is what we are supposed to take into consideration. So things such as the subject matter, the scope, the purpose, and to some extent the background of the law are all imperative in understanding the meaning of the text or the words used in an enactment. The courts should not focus exclusively on the language to the exclusion of the context in which the words are used, because that will not be a proper way to understand the words used in an enactment. And so you may see the case of Seaford Court Estates Limited against Asha, where Lord Denning was famed to have noted that whenever a statute comes up for consideration, it must be noted that it's not within human powers to foresee the manifold set of facts which may arise. And even if it were, it is not possible to provide for them in terms free from all ambiguity. Lord Denning makes the point that the English language is not one that is subject to mathematical precision. And so, because we cannot be entirely sure that we'll be precise in all our words and will avoid things such as vagueness and ambiguity, we need to understand that the judge, in approaching his task of construction, must look to find the intention of Parliament outside the walls of the text itself. And if he pays attention to the social conditions which gave rise to the enactment, he will most likely understand the mischief that the legislature intended to cure. And that would be the appropriate way to understand the true meaning of the text. Also, in the case of Northman and Barrett's London Borough Council, the court noted that any construction that is done must be to promote the general legislative purpose underlining that provision. And so judges cannot fold their arms and say that, well, this is what the lawmaker has said. If this is what the lawmaker has said, there's nothing we can do about it. So anytime I get to this point, I like to draw your attention to the decision in Humphrey Bonsu and Quaynor against another. I think that is the decision that relates to, is this section 13 of the Wills Act? As to the understanding of what a reasonable provision out of the estate would be for children below the age of 18 and the spouse, even when no provision has been made for them in a will. And the court adopted a literalist approach in that case. In that case, the decision therein has been criticized several times. When we come to interpretation of wills, it's something that will arise again. So we'll look at it. But we have moved past the stage where a judge looks to the letter of the law and says, well, this is what the lawmaker said, so let us apply it. The judge must pay attention to a multiplicity of factors and come to a conclusion or interpretation that promotes the rule of law and good governance, ensures the promotion of human rights and advancement of people's rights, ensures the creative development of the law, and ensures that we're not paying attention to technicalities and niceties of form. That is the gravamen or gist or the basics understanding that you require when it comes to purposivism. Any questions, please? Any questions, please? Please, is this clear? Is there any confusion? Is there anything I need to clarify? Can we move on? We're going to build on purposivism to go into the modern purposive approach. So if there's any misunderstanding on purposivism, this will be the best time to clarify. Great. So we'll move to the modern purposive approach to interpretation, otherwise known as MOPA. But before we go on, I need to note that the modern purposive, the purposive approach to interpretation has been adopted in some cases. You may see the case of Apia and Biani, where the deceased died intestate, and he had, among other things, an uncompleted story building which had reached lintel level, and the court had to determine whether the uncompleted story building was a house within the contemplation of the Interstate Succession Act, PNDC Law 111, under Section 4. And Lutrod J, who would eventually become, I believe, Wood CJ, noted that using a strict constructionist approach, one basic feature of a house is that it must have a roof, walls, and windows. And if this approach was adopted, a spouse or child or both may not be entitled to any house which was uncompleted. But looking at the purpose of PNDC Law 111, which was not merely to provide a shelter for a surviving spouse and the deceased children, but also to start them off financially well by giving them a significant portion of the deceased person's estate, it would be wrong to construe an uncompleted house as not a place that can be considered a house within the contemplation of Section 4. Now, if you look at the provisions of Section 4 of the Interstate Succession Act, it is required that of the deceased person's estate, one house must be chosen by the spouse and children for their purposes. And it's after that house has been chosen that they proceed to distribute the rest of the estate in accordance with the provisions set out in the Act. And the dispute here was whether an uncompleted building will suffice as a house within that contemplation. And the court in that case looked to the general legislative intent or the purpose for which the Act came about. And as you know, it was set out to provide for matters in relation to interstate succession and also provide better security for the spouse and the children. That is why they inherit a majority of the estate when somebody dies intestate. And so the court, in applying the purposive approach, understood the general legislative intent of the lawmaker at the time of the enactment and gave effect to same. to construe an uncompleted building as one in which could be considered as a house within the contemplation of Section 4 of PNDC Law 111. Similarly, in the case of Amma deceased, Inri and Amma, the court adopted this approach again, and the deceased in that case died intestate in 1980. And in 1986, after the coming into force of the PNDC Law 111, an application for the grant of letters of administration in respect of his estate was filed in the High Court. Now, Section 21(1) of the Act governed the distribution or administration of the estate of any person who died intestate before the commencement of the Act. And the court had to determine what was a claim or adjudication pending within the meaning of Section 21(1) of PNDC Law 111. There, the court was called upon because there was a claim by in that case, the court was called upon because there was no claim or action in respect of the deceased physically pending in the court at the commencement of PNDC Law 111. But the court noted that in order to avoid an unjust and absurd result, in liberally construing what exactly meant by a claim or was meant by a claim or adjudication pending, it extended it to mean actions brought after the commencement of the law. So even though the law sought to provide for claims or actions pending before the commencement of the law, the court, in adopting a liberal approach, extended it to claims pending after the commencement of the law because of the entire legislative purpose of PNDC Law 111. But it's important to note a very serious caveat that has been provided by the court in R and Barnett, where the true legislative intent cannot be substituted by a judge's understanding or view of policy. And so in your attempt to be a purposivist, you must give effect to the intent, the legislative intent, and we have demonstrated how you can gather the general legislative intent. A judge cannot go on his own frolic and replace the legislative intent with his own premonitions or values in terms of his understanding of the law. And so, there are those who criticize purposivism and the modern purposive approach to interpretation as a unfettered power granted to judges to make law. And so judges, under the guise of interpretation, are effectively lawmaking. And so those are some of the criticisms that people find with the purposive approach and the modern purposive approach. But to the extent that the judge is required to stick to certain tools in respect of underlining or outlining the true legislative intent, I think that there's a way in which we can cushion and ensure that at the very least we have some baseline with which you are working with. And so judges cannot go on their own frolic and replace the legislative intent. In any case, I'm of the view that because of and as noted by Lord Denning in Seaford Estates and Asha, the fact that there will always be ambiguity and vagueness of language, to require that we go to Parliament every time there's that ambiguity and ask Parliament to cure that ambiguity would not be consistent with common sense. And so it is imperative on a judge who has an understanding on the rules of interpretation and is well aware of the limits thereto to provide some guidance in respect of what a text means or how to better effectuate the true legislative intent and purpose. And so even though purposivism is not perfect and it has its criticisms, I'm of the view that it better provides a framework, and because of the way in which we can, if you like, speak to the tools set out for use by judges in providing an interpretation, it provides a more effective means of determining the true legislative context and intent behind any particular enactment. Any questions, please? Okay, so I need just a minute and then we'll proceed. Yes, Eugenia, please ask your question.
Please, can I be heard?
Eugenia, I believe we can't hear you, so please speak up.
Oh, hello, can I be heard?
Yes, please.
Okay, so I want to ask in a condition where you are facing an exam, that there is a test that you need to construe. Are you going to take it from your perspective if it has to do with the legislative intent or the original intent of the draft text based on the text that you are to speak to? Are you going to take it from that and then draw it down to purposive approach or modern purposive approach before you can be seen to be addressing the issue or construing that particular text?
Eugenia, please come again. I lost you a bit, so just clarify your question for me.
Okay, so when you have an interpretation question and there is a text that you maybe you need in an exams or wherever, do you have to take it trying to ascertain the intent of the draft text, as in the legislative intent, and then draw it down to maybe purposive approach or the modern purposive approach? In your understanding, is that how the trend has to be? Is that how it has to follow when you
Okay.
are met with answering an interpretation question?
So I think yesterday I made the point that when you are oftentimes and that is why you must have recourse to the past questions. The interpretation questions that you be asked, oftentimes they are not like you will not be the first person to provide an interpretation. They may be events past or events present, and so you can rely on other cases that will provide you with a certain sense of the appropriate approach to interpret it. But assuming without admitting that the question is set out in a manner that you have to provide your interpretation, you are to use the tools provided you in respect of the approaches to interpretation. And I'm saying that you may decide to go with your strict constructionist approach, but now you are enjoined by law to use the purposive approach to interpretation. So, like you said, in order to determine the authorial intent or the true intent or the general legislative intent, you must be able to draw down using the purposive approach to interpretation by looking at the legislative antecedents, the pre-parliamentary materials, the memorandum, all those other things that we've talked about that help in understanding the purpose of the enactment. And so, to ascertain the true meaning of the text, my simple answer to you is that to be able to ascertain the true meaning of the text, you must be able to provide the purpose for which the enactment was brought into force. And we have explained how you can come to the purpose. So, in answering your interpretation question, look to the text that is in dispute and ask yourself the question, what was the purpose for this enactment? If you're able to answer the question for what the purpose of or the purpose for the enactment was, that makes your life infinitely more easier. And then you can break it down to be able to determine the true meaning or the legal meaning of the text. I hope that makes sense.
Very well.
Eugenia, I hope that makes sense.
Very well. I'm grateful.
Yes, Francis, please go ahead. Francis, please go ahead with your question.
Can you hear me?
Yes, please.
So in this case, you will not be asked to as to whether you should state whether there's a purposive approach, then you explain it. Because I don't get it.
No,
If
no, no.
there's a okay.
So nobody will ask you to state whether you use the literal approach or the purposive approach. No. There may be instances where you be asked short questions, like short notes. Write short notes on the purposive approach interpretation, or write short notes on the modern purposive approach. But oftentimes, if it's a question that requires your IRAC formulation, right? What you will do is to raise the issues and say, okay, whether or not, say for instance, there's a dispute as to the meaning of person in Article 2.1. So whether or not a body corporate can be defined as a person within the contemplation of Article 2.1, right? And then you go on and do your analysis. So your analysis will explain what the basis of Article 2.1 is. Enforcement of the Constitution. It was meant to ensure that persons can bring an action in the Supreme Court to question acts that are beyond the powers of constitutional bodies and any act that is inconsistent with the Constitution. On that basis, is it fair to deduce that a body corporate should have an opportunity to challenge acts? In any case, what prevents a body corporate from doing that? Would it defeat or further the purpose of, let's say, the advancement of the rule of law and good governance if a body corporate is allowed to bring an action for the interpretation or enforcement of the Constitution? And then you can refer to your SAM and Attorney General, and then your NPP and Attorney General SIBA. So do you get the drift?
Yes, please. Yes,
So
please.
much, I'm hoping that we'll have another opportunity to meet just like around the time for your exam so that we'll solve some of the questions. But in solving your questions or in approaching the questions, your analysis will show the approach that you are using. You don't literally have to state, I am using the purposive approach. No. Because it's very rare for you to read a judgment where the judge says, okay, I know all the approaches to interpretation, but I've chosen the purposive approach. I'm doing it now. No. But just by the way in which the judge goes by his analysis, his reference to the legislative antecedents, the parliamentary material. So, for instance, if you see a judgment where they've made reference to the committee of experts reports, you don't need anybody to tell you that they are doing a purposive approach.
Very well. Very well.
Okay.
Thank you so much, Senior.
Okay. Any other questions, please?
Hello, Joel.
Yes, Faisal.
Yeah, good morning.
Good morning, boss.
I don't want to be seen to be asking for too much, but is it possible we'll get this your slides? It's a humble request. Thank you. I think it summarizes some of these things, and some of us have also joined late, so maybe it will help us. Thank you.
Okay, I'll take it. I'll take it up with. I'll speak to God about it. If it touches my heart, I'll share it with you.
Amen. Amen.
In any case, Fatah has just indicated to me that we'll make arrangements to meet just before your exams. So hopefully, once we have that time, we'll go through some of the questions. I find that the discussion on past questions is a very useful exercise because, as you know by now, you are in part 2. As you know by now, how to approach the question is majority of the marks. I mean, oftentimes you have the knowledge and the information, but just how to approach the question is usually the problem. So I'm hoping that it will allow the we'll be able to arrange and facilitate that discussion to that end. Please just give me a minute. I need to attend to something shortly, and then we'll continue with the modern purposive approach. Okay, so let's move on with the modern purposive and approach to interpretation. So naturally, this is an offshoot of the purposive approach to interpretation. It embraces that approach, but it suggests a formula to ascertain the purpose of the enactment. So we're going to do a little bit of mathematics here, right? And I mean, I'm not the most mathematically savvy person, but I think that we need a little bit of maths to be able to come to an understanding. A minute, please. Great. So the whole point of the modern purposive approach to interpretation is that they acknowledge that, well, we need to find the general legislative intent, the authorial intent of an enactment or a document or a constitution. How we go about it, we are not so clear. It tells us, well, we need to look to the legislative antecedents, pre-parliamentary materials, explanation memorandums, memoranda, sorry, and the like. But how exactly we are supposed to go about that process of interpreting is not spelled out in the purposive approach. All the purposive approach provides is a framework, a guide. What the modern purposive approach attempts to do is to provide the formula with which a judge would be able to come to a conclusion that he has obtained the legal meaning. And there are several proponents of the modern approach, but for our purposes at the law school, we focus on the stipulations outlined by Barak and Bennion. So we'll start with Barak's formulation of the MOPA. According to Barak, he believes that you ought to consider the subjective meaning of a text and the objective meaning of a text, together with the ultimate meaning or the ultimate purpose of the text, which will give you the legal meaning. There's a lot of nuancing and breakdown, but we'll do it one after the other. He says there are three tiers, there are three layers. There's a subjective meaning of a text, there's the objective meaning. These two meanings, together with the ultimate purpose of the text, would give you the legal meaning or the true meaning that helps better effectuate the intent of the legislature. Right? And he says that the interpreter cannot give the words a meaning that the words itself do not carry. So one of the criticisms that you hear of the MOPA is that, like I've noted earlier on, it encourages judicial lawmaking. But Barak admits that and says that the way in which that can be stemmed is to ensure that the judge does not have the power to give words the meaning that cannot be ascribed to it. So, for instance, the basic way to explain this is if you say Kofi is carrying a laptop, the judge under no circumstance can interpret a laptop to mean a cable. That's as basic an example as I can give you. The judge can say the laptop could mean a MacBook, an HP, or a Samsung laptop. There are various different layers or meanings that can be given to a word, but the judge cannot go on his frolic and use a meaning that is not consistent with the general understanding of the word.
Check it. Hey.
So that's the first base under which you have to understand what we are discussing. That even though we encourage a certain form of recourse to extrinsic material and other sources and the context in understanding the meaning used or the meaning of words used in a statute, the judge is not allowed to go on a certain tangent that is not consistent with the meaning. Now, Barak believes that interpretation must distill the legal meaning of the text as distinct from other meanings. Yesterday, I explained to you that a word is capable of a primary meaning, a secondary meaning, a technical meaning. But it's also, more importantly for our purposes, we are concerned about the legal meaning of the text. And can somebody remind us of what the legal meaning of a text is? What is the legal meaning? Anybody? I presume you remember, so we'll continue.
Yeah, you said the legal meaning is the meaning that the author of the text intends.
The meaning that the author of the text intends. So it is not just the ordinary meaning, but it's the ordinary meaning plus the effect. So the meaning of the word considered together with the scope and effect, or the legal effect of the word, that provides the legal meaning. Like I said yesterday, a word used in isolation may have one meaning, but when considering the effect and scope of that word, it may have another meaning in terms of its legal meaning. So Barak provides us with, if you like, a way of ascertaining the purpose of a text or ascertaining the true legal meaning of a particular text. He says first, we need to look to the subjective purpose. Now, the subjective purpose is the actual intent of the authors of the law at the time of making the law. So anytime you are looking to do a subjective interpretation, look to the meaning of the word at the time of the enactment, not at the time you are doing the interpretation, because they are two different things. Like I said, an enactment may have come into force in 1992. The Constitution may have come into force in 1993, for instance. When you are doing an interpretation in 2024, your duty in terms of the subjective purpose would be to look to the meaning of the words as used at the time of the enactment. Because language is not static, and the intent of the author has to be taken from the date that the text was particularly created. And that is the view of the subjective purpose looking at it. In terms of the subjective purpose, you may look to the internal or textual sources and the external or contextual sources. We've already explained what the internal sources would be. So internal sources would be to look at the words of the text itself, the enactments. Just a minute. The words of the enactment itself as internal and textual sources, and external sources we have explained to include all the legislative antecedents, memoranda, and all of that. Now you have to recall that when you are doing the internal source, it reflects the best way. So even though we criticize the literal meaning or the literal approach to interpretation, it is often the best way to understand what the author meant. And so the clear words used in the legislation would help you determine what the true intention of the legislator or the legislator was. But where there's a clear mistake in drafting, which makes the text unworkable, then you need to go beyond the text. I need to make this point clear that the basis of all interpretation starts from a literal understanding. Even though we criticize the literalist approach to construction or interpretation, admittedly, all forms or all approaches of interpretation have a basic framework that says, first, try to understand the ordinary meaning of the text before you do anything else. The problem we have with literalists is that after they understand the ordinary meaning of the text, they stop. They have closed. But when it comes to the other schools of thoughts, they all begin on the premise of trying to understand the intention as expressed by the text itself first. And when the text has problems, or the text will lead to an inconvenience and a manifest absurdity, then we look to other sources. All I'm saying is that in terms of the subjective purpose for Barak, he says, look to the text first. It is only when the text is unworkable or leads to an absurdity that you refer to external sources to determine his subjective intent. The next step is that even where the words are patently clear and unambiguous, it is still important to consider the text as a whole, because words are not used in isolation. The context and the whole or the generality of words used in an enactment must be considered together to provide the subjective purpose that the author intended to achieve to the text. Is this clear? Is anybody confused? Do I need to take a step back? I presume not. Okay, so for Barak, you first need to identify the subjective purpose of the text. This is important. And I said that the subjective purpose of the text is the meaning of the text at the time of the enactment and not at the time of your interpretation. And we said, how do we evince the subjective purpose? We look to internal sources and external sources. Internal sources are the words of the text itself. And we say, well, if the internal source provides you with a good understanding, then you may have gotten to a point where you have determined the subjective intent or the subjective purpose. However, if the internal sources lead to an absurdity, the judge is required to refer to external sources, and he must take into consideration the generality of the text or the whole of the body of the text to better effectuate or better understand the subjective intent of the lawmaker. And there are other presumptions, and you come to study presumptions, but there are certain presumptions that are allowable in understanding the subjective meaning. Is that the words interpreted in its ordinary, popular, and natural meaning would provide a better understanding of the text as from the perspective of the author. And so that better evinces the authorial intent. Hold on to that. Then there's the objective purpose. Now, the objective purpose is not what the author intended, but what a reasonable draftsman would have intended after considering the text, social factors, history, values, and norms of the community for which he was making the law. The objective purpose is thus usually interpreted to include the realization through the given legal text or the fundamental or core values of the legal system. Now, for the objective purpose, what we are suggesting is that, well, the author may have intended one thing, but if all things considered, if we consider our democracy, if we consider our cultural values and norms, this is what he ought to have intended. This is the distinction. For the subjective purpose, we need to know what he actually intended. This is what he meant. This is what he wanted to say. And we've outlined how we can go about it. We look to the words of the text at the time of the enactment. We try and explain it using the literal, grammatical, and ordinary meaning. We pay attention to if it will lead to a manifest absurdity before we refer to external sources. But for the objective purpose, we are looking to determine what anybody who is a reasonable draftsman in his shoes at the time of drafting would have come to if he paid attention to the context, such as social and normative values, our history, and the principles that underline our legal system. That is the objective purpose. Am I making sense?
Yes.
Please, is everybody clear?
Yes, it's fine.
Okay. So that is the objective purpose, or that is Barak's understanding of the objective purpose. And he indicates that the objective purpose is also ascertained from both internal and external sources, where the internal source, as I've explained earlier, is the text itself, and the external source is similar or related text. And so you would find that in similar legislation, the position of the lawmaker, it was expressing a certain view or a certain understanding, maybe a restrictive approach to human rights or a more liberal approach to human rights, for example. These are all tenets that a person may look to in attempting to advance the objective purpose in respect of the understanding that you must have to understanding Barak's formulation. The point is, why do we need both the subjective purpose and the objective purpose? What's the point of all this? There has to be a synthesis of the subjective purpose and the objective purpose to arrive at the ultimate purpose of the text, which will give you the true legal meaning. You must be able to marry the subjective purpose of a text and the objective purpose of the text to give you the ultimate purpose, which explains the true legal meaning of the text. The two of them, that is the objective purpose and the subjective purpose, must work hand in hand. If both of them point at one direction, then you are fine. But if they conflict, depending on the nature of the document, one would have to defer to the other. I'll take it from the top again. I'm saying that according to Barak, when you are doing an interpretation of a text, you have to determine the purpose of the text. In fact, purposivism tells us that to be able to better understand the authorial intent or the legislative intent, it must come from a place of purpose. Okay? Having established that, how do we determine the purpose? It says that, or Barak notes that we have to test the various meanings of the text against the purpose to see which meaning better aligns with the purpose of the text. That is what will give you the legal meaning. Admittedly, words may be subject to many different meanings and many different understandings. But until and unless we've tested the words along the purpose for which the enactment was made, we will not be able to understand the true legal meaning of the text. And what is purpose? Purpose includes the objectives, goals that drove the writing of the text. And so there are two types of purpose for our discussion. Under Barak's formulation, there's a subjective purpose, which is what the author himself intended for the text to achieve. And we've said that it is the meaning of the text at the time of the enactment, and it is sourced from both internal and external sources. For the internal sources is the text, the words of the text itself, and the external sources could include circumstances that led to the passage of the act or the bill. And all of these combined can reflect the intention of the the lawmaker or the legislature at the time of making the law, or the drafter of the document. So examples like we mentioned are outlined in section 10 of the Interpretation Act to include the pre-parliamentary materials and the memorandum, blah, blah, blah. That is for the subjective purpose. Then we've said there's also the objective purpose. Now, this is not what the author intended to achieve, but what the text was designed to achieve, such that a reasonable draftsman in the circumstances would have thought that the text should mean one thing. So his idea, he will consider things such as the ideas of morality and justice in society, what is fair and reasonable, and public policy and public interest. So you doing the interpretation would consider the relevant norms and societal values at the time of the enactment and ask yourself, a reasonable man in the position of the draftsman or the person who made the law, what would he have intended to have achieved or to achieve at the time of passing or enacting the law? Remember that in all circumstances, even though you are allowed to examine extra textual sources or extrinsic sources, the meaning achieved must be one contemplated by a reasonable man. That is for the objective test or the objective purpose. So for the objective purpose, you are moving out of the shoes of the person who made the law. You are saying, no, the person who made the law, let me put him aside and let me go into his place and say, if I was a reasonable man, fully aware of the context within which society was prevalent at the time, what would I come to in terms of enacting a law that solves a particular problem? What would have been my purpose? That is the objective purpose. And I'm saying that it is a synthesis or a synthesis of the objective purpose and the subjective purpose that leads you to determining the ultimate purpose. And once you get the ultimate purpose, you have achieved the legal meaning of the text. Is Barak making sense to you? Francis, go ahead.
I do not get him well. If
You
we
don't
can.
get it. Okay,
Yeah.
okay. Let me break it down. Barak says that there are two purposes of a text, or there are two reasons why an enactment, or two broad areas under which an enactment may have come into force. He says there's the subjective purpose and the objective purpose. So when when you're making an argument with somebody and the person says, oh, you are being subjective, that means that you are only viewing it from your perspective. But if you are being objective, you are viewing it from the perspective of a reasonable man. And he's saying that in providing an understanding or an interpretation, you must first identify the subjective purpose. What is the subjective purpose? It is based on the bias of the person who enacted or the person who allowed the legislation to come into force. So at the time the person was doing the enactment, what were the things that were prevalent on his mind? What did he intend to achieve? And we are saying that you can better understand that when you look to the ordinary words of the text itself. Or in a situation where the text leads to a manifest absurdity, look to other materials such as legislative antecedents and extraneous sources that will help you determine the subjective purpose. So, what was his reason for passing the law at the time of passing the law? That is the subjective purpose. Then he says that after you have determined the subjective purpose, don't stop there. Look to the objective purpose as well, such that if a reasonable man was in his shoes and that reasonable man paid attention to ideas of morality, public policy, and other considerations at the time of the enactment, what would he have meant by putting this word in the enactment? That is the objective purpose. So he identifies that subjectively, the person who made the enactment may have meant one thing, but objectively, any reasonable man put in his shoes would have meant another thing, paying attention to other factors. And he says that it is a synthesis of both the subjective purpose and the objective purpose that leads you to the ultimate purpose of the text and helps you understand the true legal meaning of a text. And so to him, oftentimes the objective purpose and the subjective purpose may be one and the same thing. They may coincide. When they coincide, you have your you have your ultimate purpose, and you are fine. It is when they differ that you are faced with some challenges, and we'll go into how to navigate those challenges. But ultimately, it's important to understand that a text is capable of a subjective purpose and an objective purpose. And when worked together, it brings you the ultimate purpose. Francis, does that make sense?
Yes, please. Now I got it.
Okay.
Yes.
Please, can we proceed?
Please go ahead.
Great. Now, the ultimate purpose. The ultimate purpose is formulated from the objective and subjective purpose. After you have determined what the subjective and objective purposes are, you integrate the two to arrive at the ultimate purpose. Now, my question is, when you are interpreting a document such as a will, which of the purposes do you think will prevail? The subjective. So, in all of these scenarios I'm going to give you, the assumption is that sometimes and oftentimes it happens that the subjective purpose is different from the objective purpose. When there's a conflict between the subjective and objective in relation to a will, which one do you think will prevail?
The subjective.
Why?
So that's the editorial intent of the testator. So that will be given effect to first. That's my reasoning.
Yes. So in terms of a will, the law ultimately tries to give effect to the intentions of the testator at all points in time. So it is only in extreme circumstances where the subjective purpose would be difficult to ascertain that we rely on the objective purpose. For wills, we are not concerned about what the reasonable man would have intended given the set of facts. We are all concerned about the authorial intent of the testator. So whatever the testator has expressed, to the extent that we can evince his subjective purpose, would give effect to that. What about if it's a contract? What
Hello,
about
sir.
if... Yes, Faisal, go ahead.
Yes, I think if it is a contract, it will be based on the objective purpose,
Why?
because with that has to do with a reasonable man's mind as
Mhm.
to how a reasonable person would have intended.
Okay. Does anybody have a contrary view? Yes, Anita. Anita.
Yeah, I think it should be subjective because with
All right.
contracts, we are looking at the intention of both parties.
Mhm. Finish your answer for me. Your answer is hanging.
So with a contract, we are looking at what each party intended to be fulfilled, and I think it's subjective.
Okay, I agree with you. For a contract, we must look to the subjective intent at the time of the drafting or at the time of the execution of the contract, what the parties intended. That is what we'll look to in terms of interpreting the words of the contract. Of course, there are instances where a reasonable man standard or the objective test is applied with respect to the contract, but generally, when it comes to interpretation of contracts, we look more to the subjective intent and we try to better effectuate that. What about if it's a statute, an act of parliament? What about if it's an act of parliament?
Yeah, thank you. In my opinion, we will have to use the modern purposive approach. And so the Barak's format is what will be applicable.
So, but I'm asking if when there's a conflict between the objective purpose and the subjective purpose, which one will prevail?
Wow.
Ifya, please go ahead.
I'm thinking the objective purpose.
Right.
Well, I know that for the subjective, it's based on the bias of the legislator, but the objective purpose also looks at social factors, values, the community, and society will always be changing. So the law would have to reflect what is currently going on in the society. The law should not be static. That's what I'm thinking.
Okay. Bismarck, please go ahead. Let me take yours and then. Bismarck, or you've changed your mind. Anyway, when it comes, yes, Bismarck.
Yeah, I think I wanted to say what Etia had said. It's being objective because at the time a statute is being made, you look at the social development, the cultural values at that time. So I was thinking that it's objective.
Okay, so for statutes and constitution, go and read the case of Asari and Attorney General 2004, and then you find the answer there. When you find the answer, especially in the case of Ifya, I want to hear from you what answer you find. So Ifya, please let me know what answer you find. But the answer is in Asari and Attorney General. And when it comes to statutes and constitutions, you have to do a balancing act. So it is not set in stone to say that you do the objective or you do the subjective, depending on the question that you are faced with. Sometimes you must defer to the subjective intent, sometimes you must defer to the objective intent, especially when there's a clash. So it is always a balancing act. And especially when it comes to the constitution, there's no straight-jacketed approach. Like we said, a strict doctrinaire approach to constitutional interpretation is most undesirable. So it's always a balancing act to determine at that point in time what better effectuates the true intent. And it's important that you are able to provide that meaning in the context of the task that you are faced with or the text that you're interpreting. Faisal, please go ahead.
Yeah, mine is a question. Did you say Asari versus AG 1994?
2004, please. There's no Asari AG 1994.
All right. Thank you.
This is on the swearing in of the vice president. Or, I mean, the swearing in, those Articles 60, 11, and 68. If your hand is up.
Yes, let's take you back a bit. For the contract, you mentioned that we would use the subjective purpose, which is the intention of the parties.
Yes.
But sometimes with certain acts, you know that the intention may not be clear. So there's always the difference to the act. So one act, for example, like a sale of goods act, then you defer to the a contract for sale of goods, you defer to the sale of goods act. So would that then move to objective?
Yes, it will.
So the intention is not clear, that is.
Absolutely. Thank you for that. I think I should have made that point clear that oftentimes the basics of wills, contracts, and non-statutory documents always proceed on a subjective purpose. But when the subjective purpose is unclear, that is where we defer to the objective. So like you mentioned, in the contracts for the sale of goods, when the parties themselves have adopted certain terms, the court will defer to those terms. This is only when those terms are unclear or those terms are unlawful that the standards provided by the Act, the Sale of Goods Act, for instance, will be applied. And when we come to do the interpretation of non-statutory documents, which I hope we will be able to cover tomorrow, you'd realize that when it comes to those documents, we always proceed on a subjective purpose before we move to any objective view of the interpretation that we are doing. So, like you rightfully pointed out, yes, the contract will be interpreted subjectively unless and of course a subjective interpretation would not ascertain the true intent and would lead to a manifest absurdity or an inconvenience, then we may defer to the objective intent. So that is it for Barak. There's not anything sophisticated. Then there's Bennion's formulation of, so you may look at the Ghana Lotto case as well, Ransford France as well, ex parte Yali, and Adolfo and others against the Attorney General. These are all cases that spoke to Barak's formulation of the MOPA and how it has been applied in Ghana. Let's look at Bennion's view on MOPA. Bennion's view is a much more straightforward and simple approach. He says that the MOPA is a two-step approach to be used by the court in determining the meaning of words used in the statute. And he posits that the MOPA is an offshoot of the mischief rule established in the Hayden's case. We discussed the Hayden's case yesterday, and his approach is two-legged. The first one is what is known as a purposive and literal construction. He says that where words, in this instance, words are to be given their plain and ordinary meaning if the plain meaning is in accordance with the legislative purpose. So according to Bennion, the first step to interpreting any text is to provide it with the plain and ordinary meaning. And once the plain and ordinary meaning accords with the legislative purpose, then you are home and dry. You are done with your interpretation. He says that you only move to the next step if the word is capable of a strained meaning, and to be capable of a strained meaning where the ordinary meaning is at variance with the legislative purpose. And this is referred to as the purposive and strained construction, or purposive and strained interpretation. So in effect, what Bennion is telling us is that when you are interpreting a text, and so, I mean, Bennion's view is much more, if you like, embracing of the literal approach to interpretation with some few tweaks here and there. His view is that when you're doing any interpretation, your first step is to ascertain the ordinary meaning and determine if it accords with a legislative intent. We know how to determine legislative intent. We have spoken about this. Section 10 tells us how to determine the legislative intent. So if the ordinary meaning accords with the legislative purpose or the legislative intent, you are done with your interpretation. However, if the ordinary meaning of the words do not accord with the intent of the lawmaker, then you do what is known as a strained construction. So his approach is 1, a purposive and literal construction, or 2, a purposive and strained construction. You do step 1, and only if necessary would you go on to step 2. So for instance, in the case of ex parte Yali, the court noted that where the purposive and literalist approach, which is similar to the subjective intent, advances the legislative intent, there's no need to apply the strained approach or the second approach. Basically, that is it for Bennion. And you marry the two, right? You marry the two, Bennion's view and Barak's view, to establish your understanding of the modern purposive approach to interpretation. And the goal of all of this, all of that we have discussed this morning, is to ensure that when you are faced with a text to interpret, your first instinct is to understand that the default view now in terms of approaching the interpretation, especially of statutes and constitutions, is to look at it in terms of a purposive approach. And of the purposive approach, we have tools, we have materials that help us understand how to ascertain the purpose of a text. And a further nuance or a further understanding to that is provided in the modern purposive approach to interpretation, which is that you find the subjective meaning or the subjective purpose of a text. The objective purpose of the text helps you determine the ultimate purpose, and the ultimate purpose allows you to arrive at the legal meaning of the text. And then, according to Bennion, you do a purposive and literal interpretation. And so if the literal interpretation accords with the legislative purpose, you are fine. But if the literal meaning is not in accordance with the legislative purpose, then look for some other meaning, which is the strained construction that will enable you come to that understanding. That is it for MOPA purposivism and our discussions for today. Any questions, please? Yes, if you
Yeah, okay, this is not a question. I think I was checking the case and I think I saw what you were trying to draw our attention to. So thank you.
Okay. Any other questions, contributions? I promised somebody something yesterday. I don't remember. If a person could remind me so that I could do it now. Yes, Faisal.
Mine is, I just want to reiterate my appeal to what I requested earlier. And I pray that the Lord descend and touch your heart for you to.
I'm doing some 3 days dry fast. So maybe after the fast, then we'll see about that. Anyway, but I'll share it with you. But out of the abundance of caution, this is for your studies. It's not for I mean, there are those who use these for all manner of things. And of course, it's also subject to a disclaimer. If there are things in there that you do not agree with, we can discuss. And I don't purpose to be a repository of all legal knowledge. So I'm subject to correction as well. Yes, Tommy.
Yes, Telfer. Today I couldn't join earlier. I was the one who asked you the question on the semantic and syntax ambiguity, which you said you were going to address before you start off today's class. I don't know if you would take it or maybe tomorrow.
Okay, so let's defer it to tomorrow, so that tomorrow you come early.
Tomorrow I'll join early. Early.
Once I know you are here, then I'll explain, so that I don't explain and you come back and tell me you are
Absolutely.
not here.
Absolutely. Okay.
Thank you so much.
Thank you.
Any other questions, concerns, clarifications, additions? Yes, Eugenia.
So I would like to ask with the objective in ascertaining the objective, is it only limited at the time of enactment, or you can also look at it at the time of interpretation, since we are talking about modern purposes?
Come again. Please come again.
I'm asking that with the objective, ascertaining, you said subjective and then objective intent of the drafter when we are looking at it from purposive interpretation. So I'm asking you straight on the fact that you look at the subjective intent at the time of enactment and then the objective intent of the drafters at the time of enactment. So I'm asking that since we are looking at it from a modern purposive approach to interpretation, should you also look at the objective at the time of interpretation, so that you look at how far the law have traveled and our values, the democracy, and then all our culture as a nation? Do you also look at it from that point, or you limit it only at the time of enactment?
So you look, broadly speaking, the primary view is you look at it at the time of the enactment, what a reasonable man would have intended. But your interpretation, but then that is when you get to that point of determining the subjective and objective purpose. But your interpretation must not stop there, because you are enjoined by the law, which is the Interpretation Act, to also have consideration of a creative development of the law. So after you have established your objective purpose, your interpretation should also be mindful of all the things that you've spoken about, to ensure that whatever ultimate interpretation you come to also has regard for that. But when you are doing the primary task of determining the objective and subjective purpose, as for that one, you are looking at it at the time of enactment, because you are trying to establish that the words must better reflect the intention of the lawmaker at the time he made the enactment. But after you have crossed that bridge, your interpretation must also be in tandem with the general idea that underlines the Interpretation Act, which enjoins us to ensure a creative development of the law. That's why I made the point that even though the approaches are important, the approaches, you do not necessarily have to use one approach to the exclusion of the others. The approaches come together. The approaches, the rules, and the aids, they come together to form one corpus that allows you provide a holistic interpretation to the text that you are using or you are being called on to interpret.
Okay. Okay. Thank you. Okay. Thank you.
Okay. Any other concerns, additions? Okay, so I believe tomorrow, we have set the ground for us to begin our discussion on the introduction to interpretation of non-statutory documents, and hopefully we'll be able to cover significant ground tomorrow as well. So thank you for joining me. Please enjoy the rest of your day, and good luck.
Thank you very much.
Thank you very much
Thank
to
you,
you
Doc.
and to
Thank you.
Thank you
Thank
very
you.
much. God bless you.
that put one more ass. Since Richard put his bumble ass.